DRT. Okay, so that is very simple one. So first of all, the summary we will do that there was need to have a effective law for recovery. Prior to this act, the recovery law were found inadequate, because we know that before this act, because this act was come into picture in 1993. 1993, right? And before this, the court handled these types of cases. Huge assessed of banks were involved in the recovery because huge pendency of the various court. Exactly. Suppose before 1993, when any case was, come in front of the court, so I think the court will not give the special weightage to the particular bank. Okay, so that's why they need to require. Okay, they need to require a particular, you know, we need a particular law so that the only debt recovery matter can easily be solved by the persons. Okay, so this affect the financial sector. The act was introduced in 1993. Initially, Delhi High Court decided the act as a constitutionally invalid. Exactly. The Delhi Bar Association, they just filed the case in the Delhi High Court that this DRT Act is totally unconstitutional, violation of Article 14. But when we just appealed to the Supreme Court decided no, 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 this act is totally valid, because this act is made for the particular things for solving the dispute. So that's why this act is totally a valid act. Okay, now applicability of the cooperative in this bank, the DRT Act will be not apply because there is a special provision. By the amendment in 2013, the applicability was extended to the multi-state cooperative bank. Okay, so it means that when it was decided by the Supreme Court that this act will be not apply, but now in 2013 this will apply to the multi-state cooperative banks. So preamble to the act state that the act is for expedience of adjudication and recovery debt. So the act is applicable for the depth of 20 lakh. This is very, very much important. Before it was only 10 lakh, but after that, after amendment, it was 20 lakh. So this is again important. Okay. In 2019, the name of the statute was changed to the Recovery of Debt and Bankruptcy Act. And before it was something like Recovery of Debt due to the Bank and Financial Institution Act. This was the act name. But after in 2019, the act name is this. So this is important from the examination point of view. Now let's do the question. DRT Act is applicable only if the debt recover is above 15, 10 or 20 lakh. What is the right amount? So for the right amount is that is a 20 lakh rupees. Okay. The debt recovered to DRT may be secured and unsecured. It means suppose if the borrower have taken money from the bank and financial institution, right? And something we have to security we have to give. So that is what? Secured or unsecured? So this is totally true. Okay, it may be secured, it may be unsecured. Overdrawn amount in an account is not debt recoverable under the DRT. That is true and false. Tell me. That is true and false. Overdrawn amount in an account is not in a debt recoverable stage. The third one is totally false. You have to remember. If a civil court has passed a decree, it has to be executed through that court only and cannot be come to the recovery tribunal. That is true. I don't think we have just done this. Suppose if civil court pass any decree and it have to be executed, and suppose this act come into picture. So this order can be executed by the tribunal also. So this is totally false. Is that okay? This is totally false. Next, that is a new segment. Okay. DRT was established by central government. The government also decide their jurisdiction. The tribunal consists one member, that is the presiding officer, that is the head of this one, appointed by central government. The central government can also notify to establish such DRT and its benches at it may be necessary, and thus give the jurisdiction, power, authority, etc. Okay, and a new act is also come into picture, that is Insolvency and Bankruptcy Code 2016. What is the eligibility of presiding officer? Minimum, he should be the district judge. Tenure is 65 or 5 years. Okay, whichever is earlier. And one and more recovery officer can be also appointed by the recovery officer by the central government. If you want to appeal, so filing appeal, the central government appoint appellant recovery tribunal, that is a debt appellant recovery tribunal. The head will be chairperson, and the qualification of chairperson must be minimum high court judge, presiding officer of at least 3 years, and legal officer of grade 1 post. So these are the qualification of this appellant. The appointment of this one is 5 years till he attend the age of, this is the qualification of what? This is the qualification of your this one chairperson. Okay, so that is important. Okay. Done, guys. So 5 years, 70 years, that is the tenure of this chairperson. The presiding officer and the chairperson can resign from the office, but they have to give 3 month notice to the central government. And central government can also, if it is proven misbehavior and incapacity, he can also remove the chairperson and the presiding officer. Okay, so this is the segment. Now next, DRT is established by, tell me. DRT is established by, that is the central government. Okay, DRT consists the benches of 3 persons. That is totally false. Jurisdiction of appellant tribunal is with the respective of high court. That is true. That is not true. That is a false, because tribunal have a separate criteria. Can the order of central government in the appointment of presiding officer of the tribunal can be challenged in any court? Can order of central government in the appointment of this can be challenged in any court? This is absolutely no. This is absolutely no. So for this one, B is the right answer. Okay, I think the all concept are very easy for you people. Okay, now let's do next. Okay, the bank has to file application for recovery of loan dues under the DRT, which is not paid by the borrower. Exactly, taking into consideration the jurisdiction and cause of action. Other bank and financial institution there that are also creditor to the particular borrower can join the application. Exactly. Suppose class, this is the borrower. The borrower had taken loan from the B1 bank, and borrower also taken the loan from B2 bank. Okay, this is the borrower. Not able to pay the loan to this and to this also. So B1 just filed the case to the DRT. B1 just filed the case. Just see the diagram. B1 filed the case to the DRT. So if the party is same, cause of action is same, so he can also file the case and the cases will be merged. So B1 bank case, B2 bank case will be merged. So this is your, this line. Other bank also creditor to the particular borrower can join the application. So this is the right answer. Okay. For transfer from civil court to tribunal, no fresh fee is required to be paid. This section has given elaborate provision of the summon and hearing. That's it. Is that okay, class? Okay. The tribunal can pass interim order to prevent defendant from transferring his property. Interim order means that the mid order. The DRT is fully empowered to pass comprehensive order like civil code. So they have a same power just like civil code. This section also give the procedure for issuing the recovery certificate. So there are provision for appeal to the DRT. So we know that class DRT to DRAT. We have to file the case, okay, to the appellant tribunal. And for this one, we have to pay the 50% of amount. That is important. And the limitation apply for the DRT cases, which means bank has a normally file the recovery application within 3 years in the cause of act. It means DRT to DRAT, 30 days is there, right? And from this 3-year limitation period is there. Suppose if borrower or the bank want to file application, so there are 3 year of the limitation. That is important. Okay, this is important. Any doubt? Okay, now let's do the question. DRT jurisdiction for a bank is where head office of the bank is located. Tell me. Yes, class. DRT jurisdiction for the bank where the head office of the bank is located. That is absolutely false. If a bank has filed recovery application, other bank can join the application if the defendants are same. Defendant means the borrower is same. That is absolutely true. When a case gets transferred from civil court to tribunal, the fresh court fee is required to be paid? No. A counter claim filed before DRT has the same effect as the C class. In civil case, we know that the plaintiff is there and defendant is there, right? So plaintiff means the person who filed the case and defendant to whom we are filing the case. So defendant when counter claim, right? So the plaintiff is basically what? Plaint. The plaintiff will always file the plaint. So in that case, the plaint is the right answer. Plaint means when the plaintiff has to be filed the case. That is called plaint. That is important. Since DRT is not a civil court, it cannot pass interim orders such as attachment, injunction, receiver. That is true and false. Fifth, this is totally false because DRT is not civil court, but it can work just like a civil court. A person who has filed before appellant tribunal has to pay how much of amount? 50% of the amount. Okay. While filing appeal before appellant tribunal, if any amount is required to be deposited, A option is no amount is required to be deposited until appellant tribunal decide. Yes, court fee of the appeal amount is required to be paid. C. Yes, 50% of the amount determined by tribunal is required to be deposited at the time of filing of the appeal. And D. Yes, after admission of the appeal, 50% of the amount determined by tribunal is required to be deposited. So how much money that is required to be deposited? Tell me, class. That is C. C is the right answer here. Okay, C will be the right answer here. Done? Next. On receiving recovery certificate, the recovery officer has to proceed for the recovery by attachment and sale of movable and immovable property of defendant, arrest and detention. It means these are the power of recovery officer. These are the power of recovery officer that he can attach and sell the property of borrower or arrest and detain the person or appointment of receiver, etc. Defendant is debarred from disputing the correctness of amount to the in the recovery certificate because defendant only presiding officer have a power. I think we know that for this one. So the presiding officer can correct the clerical and arithmetical error. This section has given wide enabling provision that call the money from the third party in whose hand defendant money is lying. Okay. It means we can suppose if the borrower money is within the hand of third party, so we can also call third party regarding this one. So that is important. Next. When amount belonging to defendant is in third party, the recovery officer issue notice calling for the money. The third party on failing to pay is deemed to be as a defendant. It means if third party is not giving money to the borrower, so that third party is also called as a defendant. If there is already a decree passed by civil court, DRT can issue recovery certificate. Exactly. No need to start the case from the beginning. Okay. The chairperson, presiding officer, staff of tribunals are deemed to be public servant. They are also protected from any accident for their done in good faith. The act has overriding effect when there is an inconsistent with any other law. It means this act will supersede. This act will class supersede. First question. First question class, that is recovery officer appointed under DRT can attach, sell movable and immovable property against whom the order of the is passed by the party. That is true and false. Tell me, that is true and false. That is true and false. That is absolutely true. The defendant can raise a plea before recovery officer about correctness of amount ordered to be paid. Yes. The defendant can plea before recovery officer. That is absolutely false, because we know that only presiding officer have this one. If recovery certificate has clerical and ethical mistake, that can correct the same. Who will correct? I think we know that. That is presiding officer. Okay. For recovery of recovery officer can adopt the same method that apply in the income tax under the Income Tax Act. I think this line we have just read it. This line we have read it. For the fourth one, this is absolutely true. Okay, this is absolutely true. Recovery officer can ask the defendant to furnish by affidavit particulars of his assets. Fifth one. Recovery officer can ask defendant to furnish by affidavit particular of his assets. Assets means this belongs to me. That is absolutely true. A company is under winding up process. Okay. Whether High Court permission is required to a bank to proceed against it before the DRT. That is true and false. Sixth one. This is very important, and I think this thing we have just read it. That is no, because DRT Act is being special law, has an overriding effect over the other law. So for the sixth one, E will be the right answer here. So I hope so, guys.
I hope so you people like the session. So today we have just covered the MSME and your insolvency and bankruptcy code. So if you want to join the session, this is your AIM batch. Okay, you can use the coupon code Y391 for the maximum discount up to 81%, right? So this is your CAIIB AIM batch. Okay, this is your CAIIB AIM batch. You can see here, you can purchase the batch. In the batch, you will get the live classes, recorded session, PDF, mock paper, etc. So if you want to enroll, you have to use the coupon code Y391. And this is your elective paper video course, because in the single paid batch, the video course are not available for elective paper. If you want to join the live classes of elective paper, so it will be available in the CAIIB ka Mahapack, because in CAIIB ka Mahapack, you will get everything for 1 year. Okay, if I just show you the Mahapack, this is your CAIIB ka Mahapack. So if you want to enroll it, you have to use the coupon code Y391, and on the occasion of Holi, the discount is going on, right? So if you want to purchase it, the process is very simple. Google Chrome, click, okay. Then after you have to write down Adda 24/7, click on all courses, done. And this is CAIIB June 2024. First of all, this is your AIM batch. This is CAIIB ka Mahapack. So if you want to purchase it, click on buy now, put the coupon code Y391. If you click on apply, you can see 80% discount is there. That is for the 1 year of validity. Is that okay? So you can see here, include all the new and updated syllabus, include mini marathon, mega marathon, so everything, whatever you want. And elective paper live classes will be also available in this CAIIB ka Mahapack. So enroll it now to just clear your concept and crack this exam in the single and a first attempt. So that's all for today's class. Have a nice day.